for organizing this conference and for his daily commitment in human rights. And thanks also to the NGO Center for Civil Liberties. So I will share my screen with you with my presentation. Okay. So when I started writing this presentation, I was searching for news related to my topic. And I realized that the consequences of using national security as an exception of data protection went far beyond what most Europeans can imagine. In order to understand this, we must first understand what personal data is concretely, but also in law. And to do so, we will start with a quick demonstration of something that most of us do very regularly on the internet. So I tried to create a Snapchat account to make this presentation and to understand which kind of data are collected. So for creating a registration on Snapchat, we have to open the application to put your name, an email address, a telephone number. You have to choose a password and give access to your camera and microphone. So this is the first category of data. And it is more or less the same for Facebook. And after it, I tried to make an Amazon account, and we have to add also your personal address, your bank account numbers. And with all this data, we have like a group of data. And I really don't remember how many accounts that I have in my personal life in internet. So if we add also the professional one, this creates an enormous quantity of data. And those data are divided into categories. The first one is the personal data. As I said, name, date of birth, place of residence, nationality, a photo, a voice recording, a fingerprint, an email address, a telephone number, a social security number, an IP address, a computer login, and even more. And this data is stored for a specific purpose because an obligation, a legal obligation. And for example, your name, your address, and telephone number are used to deliver your product from Amazon, for example. And the use of this kind of application will create another category of data, which are non-personal data, and allow the creation of metadata. How does it work? We have to understand it by another example. So I choose to use Facebook because it's the more simple in my sense. Using Facebook, you create connection data. Connection data is where are you connect from, which device is used, the time of your connection, and which service do you use on Facebook. And this number of data will give a lot of information of your personal life. So for example, your first connection on Facebook of the day indicates approximately the time you get up, and the last connection is approximately the time you go to bed. So by analyzing this completely anonymous connection data, it is possible to create metadata. And to understand how deep we can go with this metadata, we use the example of Mr. X. Mr. X always connect at 7 o'clock every morning during the week, and COVID appears. COVID appears, and now on Monday, Wednesday, and Friday, Mr. X connect at 8 a.m. So Facebook know when Mr. X is teleworking because he started the day 1 hour after than the usual. So, but Facebook also knows that before COVID, Mr. X take, for example, transport, because during, I don't know, 10 minutes, he don't have connection because of metro. And with all the metadata, we can know you more than with your personal data. Is even more efficient and more logical to know your personal life without your name. So it's very a huge problem that we have with all the GAFAM. And now that we understand what is personal data and non-personal data in practice, we will check that what is personal data in law. Oh, sorry. So in law, under Article 2 of Convention 108 plus and Article 4 of GDPR, personal data means any information relating to an identified or identifiable individual, that is the data subject. And the GDPR precise that an identifiable natural person is one who can be identified directly or indirectly, in particular by reference to an identifier such as a name, an identification number, a location data, an online identifier, or to one or more factors specific to the physical, physiological, genetic, mental, economic, cultural, or social identity of that natural person. So now, if we certain information that don't fit with this definition, is very difficult, because we always let like an identifiable number, a name, a surname, a user number, always. So the protection of personal data is in fact derived from the right to privacy under Article 8 of the European Convention of Human Rights and the Charter of the Fundamental Rights of the EU, which became binding with the entry into force of the Lisbon Treaty, provide directly in Article 7 the right to private life, and under Article 8 the right to protection of personal data. So they are equal in the Charter, and in the Convention of the European Convention of Human Rights, sorry, we use the Article 8 to protect the private life. And we have another convention. This is the Convention 108 and the Protocol Convention 108 plus, which protect the personal data. So however, the right to privacy and the right to protection of personal data are not intangible rights. So they know exception. Under the Article 8 of the Charter, the exceptions are not directly provided in this text, but we find it in the GDPR text under Article 23. And sorry, on the yeah. And in the Convention 108 plus, we found the restriction of these rights under Article 11. So with other, we found it with other restriction like national security, what I said, defense, public security, the prevention, investigation, detection, or prosecution of criminal offense, etc., etc. And under Article 11 of Convention 108, there is more or less the same, but we have less restriction than in the EU because we don't have the economic logic. So we will zoom in the topic of today, which is the national security, as an exception of the personal protection of personal data and how the national security became an exception to data protection. So first of all, we have to have a point of the genesis of the concept of national security, which is the adoption of a political concept by legal tools. First of all, I tried to find the definition, literary definition of the security, but also the national security, and what is the opposite of that is, for me, the danger. So Cambridge gave me the definition of the security, which is the protection of a person, building, organization, or country against threats such as crime or attack by foreign countries. And about national security now, the safety of the nation or action taken to protect it. And we have, as example, a threat to our nation, to our national security, and money spent on national security, which for me is, it needs to be more precise, but this is the Cambridge definition. And the opposite of the security for me is the danger, but national danger doesn't exist. So danger is the possibility of harm or death to someone. So we have, as example, danger, keep out. He drove so fast that I really felt my life was in danger. So we have a lot of examples like this, a common example of a danger. And as you can see, even in a dictionary, we don't understand really concretely what is national security. And what is in, what is out of this definition, we don't really understand. So I decided to take the Sophie Inveld speech on computer privacy on Data Protection Conference 2018 to give you a very good counter example of the search of definition of national security. First of all, she said that the point about national security is whatever the definition is, it creates a carve out from the normal rules. The normal rules don't apply in a national security area. And what do we mean by national security? She said that she gave the example of the domestic violence, and she said that all the means invested in the fight against terrorism, which has been justified by national security, that's not a very effective way to providing security. Because if we take those means and put it in the fight against domestic violence, we might actually save many more lives. And we can add to this point, fighting against the being drunk during driving, I don't know, AIDS actions, and there is a lot of more example about saving life than the national security. So in my opinion, using a very wide notion aims to be able to use it as our society evolves without too many legal and procedural constraints. It is also about reassuring a citizen about the struggles that our current government can lead. And to understand, we have to zoom in at the emergence of the security movement in Europe that starts in 2000, 2001, more or less. So where this concept come from? Sorry. Okay, the national security is a recent concept that came into being as a result of the terrorist attacks that took place in the West. It is the legal translation of a political reaction to these events. What were the national and European reaction to the terrorist event that we can ask us at the moment? So it starts with the Twin Towers attacks in New York City on September 2001. Attacks also took place in European countries little later, and marking a turning point in various defense policies on the member states. When I said member state, it can be EU member state, but also Council of Europe member states. And the attack of 2004 in Madrid, which led to the adoption of the European Union counter-terrorism plan, illustrates the security reform taking place in the post-2001 period. The threats to the internal security of states have changed because of this events. And after that, the EU is adopting various instruments to step up the fight against the terrorist threats. Firstly, in 2002, that you can read it on the presentation, the Council adopt a common definition of terrorism in a framework decision. And it shows that we now don't have the same logic as before, because just after the World War, we were fighting against countries, but now we fight again like non-state armed group like Al-Qaeda, Daesh. We have in Spain the ETA. In France also we have some regional groups like that, and more in the start of 2005 on those years. But so in 2002 the Council adopted this definition of terrorism, and the same year European coordinator for the fight against terrorism was appointed by the High Representative of the UN for the Common Policy, Foreign and Security Policy, sorry. So in addition, the Council adopted the framework of decision establishing the European arrest warrants to speed up the transfer to detainees between the various judicial authorities of the member states. These different legal tools have emerged under the influence of member states, but also the intergovernmental logic of the Council of the European Union, because as we will see, they have a very sovereignty position in the EU debates. And the European government had focused their policy on this security objective, adopting several pieces of legislation in response to the attack of European countries. This approach affirms a strong support to the United States, but also a change in national defense policies. And we see a new vocabulary emerging in EU. So this is illustrated by a European Court of Justice case, which name is PNR, Passenger Name Records, which is an agreement between United States and the EU, which aim to ensure security at airports and on board during flight. The judge notes that following the terrorist attack of 11 September 2001, the United States passed legislation in 2001 providing that air carrier operating flights to or from the United States or across the United States territory had to provide the automated reservation and departure control systems referred to as passenger name record. So in reaction of a terrorism attack, we have to make like a convention between the United States and the EU for all the fly we exchange. That means if plane go from Paris to New York to Venezuela, we have to provide all the information of the passenger, even if the plane just pass by the territory, just across the territory of the United States. So Western states since 2001 have been working on their security policies, both internal and external, as this PNR Accord shows us, in order to looking beyond, national defense to several aspects of their citizens' life, such as transport, as we can see. And in French law, for example, the threats to our nation today are no longer exclusively military. In order to draw the consequences of this development, the new penal code replaces the notion of the state's security and national defense with the broader of notion of fundamental interest of the nation. So this change initiated the genesis of national security, and which encompasses both security and defense in one notion, and at the same time takes on a new area which were indifferent to law and order before all the terrorist attack and all this governmental movement. So the concept of security allows for a more effective response than its predecessor to these evolving threats, and in particular to terrorism, because terrorism evolves very fast and quickly, and they always use the new technology to develop their actions. And yes, because it's logical, because national security has a wider scope than the public security or the defense, for example. And we have in Europe a lot of action plans which have emerged in the quest of security. The multitude of forms and methods used in this respect allow them to adapt quickly to the issue involved. Several measures have been adopted in the field of transport security concerning the free movement of European citizens or third country citizens, or financial measures concerning the economic resources of certain terrorist groups. So after we've seen that this is a political concept, we will see how the legal tools adopted it. So the EU, the Council of Europe, the UN, and a lot of countries adopted during the last 20 years, lot of legal instruments,
Yeah, please continue.
Okay. A lot of legal instruments, first to assert their position against terrorism, and then to frame the fight against terrorism. So both are an objective, and they adopt a lot of legal tools to fight the ideological terrorism. And so we have an extraordinary meeting on the 21 September 2001 of the European Council, where the Council declared that terrorism was a real challenge for the world and for the Europe, and that the fight against terrorism will be a priority objective of the European Union. Also on September 2001, the UN Security Council adopted a resolution setting out strategy to combat terrorism by all means, and in particular, its financing. And we can see these movements in the jurisprudence of the European Court of Justice, with, for example, the judgment of HT versus Landbaden. I don't pronounce Germanic word, but you have on the screen. And this case is about the Directive 2004/83 on refugee status condition. So it is the third country citizen and their move in the Schengen space. So in this case, judge clarifies the interpretations to be given to Article 21 of the directive, which allows a residence permits to be revoked. So national security is an exception of this right and can permit to revoke resident status. So the judge said, paragraph 52, moreover, as the advocate, etc., such as an interpretation is supported by the travaux préparatoires of Directive 2004, which show that Article 24(1) of that directive was inserted on the proposal of the Federal Republic of Germany following the attack in the United States of America of 11 September 2001. And we can see after the possibility to restrict under certain specific conditions the movement of third country nationals within the Schengen area with the goal of combating terrorism and thus containing threats to national security and public order. So we can see by this case that the political concept of national security came from terrorism and is used to restrict fundamental rights in the EU. The terrorist attacks that marked the beginning of our century had many repercussions on the orientation of the policy, with an increasing emphasis on security issues. So these events have placed a significant responsibility on, first, the European legislator in the legislative process, as we will see on the GDPR, but also on the institution of the Union's external relation with the rest of the world. So we can see that even in Europe, the terrorism question is very, very present, but in the contact of the Europe with the rest of the world is also a major preoccupation. So the relationship between the policy and lawmaking has had to take into account new grounds for limiting rights in the name of national security. Without giving any juridical definition of it, the legal tool provides this exception directly in directive or regulation. And now, what about the data protection framework? So, okay, sorry. In the data protection framework, this the national security exception appear in reaction always in reaction of terrorism in 2001, And in the Privacy Directive of 2002, we have the Article 50 of the directive that states member states may adopt legislative measures to restrict the scope of the right and obligation provided for in Article ta, when such restriction constitutes a necessary, appropriate, and proportionate measure within a democratic society to safeguard national security, between parentheses, that means state security. And and the special regime of the protection data during 2002 new grounds for limiting this fundamental right if we compare with the 1995 directive of the EU about protection of personal data. So national security in 2002 directive is used by the legislator as a synonym of the state security, as it is specified in the article. This evolution of security policies led to the legislative process of the General Data Protection Regulation. The search for a balance between the security issues and the protection of personal data was a great of importance for the legislator itself, and also for other actors as the European Agency for Fundamental Rights and the European Data Protection Supervisor. So we had like a movement during the adoption of the GDPR, and we see during the negotiation of the adoption of this text, the national security exception was brought into the debate and finally included in Article 23 of the regulation by the Council of the European Union. So it's like a response to the intergovernmental logic of the Council of the European Union. So the current version of this article bears the stigma of the omnipresence of the security in the logical of the Council. So the addition of this ground by the Council reaffirmed the state's sovereignty, which is absent from the public safety, because the public safety have a common definition and a global definition. And this substitution of national security for state security, what's happened in the GDPR during the debates, which is a principle linked to the field of defense, marks a change in the evolution of the legal vocabulary. The notion of the national security affirms the governmental and regalian character of the security because it's national. So because of the influence of terrorism on legal grounds, we have like a multi-sectoral consequences on media, politics, law, defense, even transports, and it highlights the regalian prerogative of the states in the exception of those rights. So now I just make like a little break to show you the difference under the Council of Europe conventions. In the first convention, Convention 108, we have like Article 9, and we have protecting states' security, which is more or less the same than national security. But I think that the Council of Europe, having a lot of more country and a different way to organize the legislative process, it can justify why we have the state security here. And after in 2018, sorry, we have the protection of national security as an exception of data protection. So you will find it in Article 9 of Convention 108 and Article 11 of Convention 108 plus. And I make another point under the EU law. You have in Directive 2002 the exception for national security, with that mean state security, because we were in 2002, and in GDPR 2014, because the text wasn't like this during the debate, the negotiation, but in 2014 you just have public safety and the prevention, investigation, detention, or prosecution of criminal offense, etc., etc. And after the influence of the council, you have the national security as an exception. They add also the defense and a lot of other exceptions, economic one, and the other exceptions that you can find in Article 23 of GDPR. So it's quite interesting to have like a chronological vision of the debate on data protection. And to having all those information, I write to the parliament to have all the paper on of the debate during the adoption of GDPR, and they send me the text date by date, and I really saw that at principle we didn't have this exception of national security, so it's very interesting. So now why this concept is problematic if we use it as an exception to the fundamental right of the protection of data. So using national security in law can be, yes, problematic because, as we saw just before, it has a political nature, and national security will then have to be translated into precise terms, allowing for some clarity in the interpretation of law. And this is the failure of the European text that I criticize today. And the consequences of the lack of the precision directly affect the fundamental values of our society. So the lack of clarity regarding national security concepts, we can first have a zoom on legal definition of the national security. In the EU, this definition doesn't exist, and in the Council of Europe area, it doesn't exist too. So, in absence of a common definition of national security, we can search some response in the jurisprudence. So in jurisprudence, we have a very recent evolution, but the problem is still existing, because we will see that we have a very, very lack of precision around this notion. So for many years, there was no definition of national security, and indeed, the judge often used the term of terrorist directly rather than national security. We had an evolution on last October under the European Union, the Court of Justice of the European Union. In the 10 October 2020 with the Quadrature du Net case. The Court of Justice has just handed down a long-awaited decision on surveillance. For nearly 15 years, the French state has imposed on internet and telephone service provider to keep the connection data that we spoke during the introduction of the entire population, so maybe me. And that's mean who talks to whom, when, and from where. So La Quadrature du Net, which is a French association, along with other associations, challenged the legality of the French law in this area. Several preliminary questions were addressed to the judge in Luxembourg. The question that interests us is okay, sorry. The question that interests us is with regard to the interpretation of Article 15 of Directive 2002. The referring court wondered, firstly, whether a generalized and undifferentiated retention obligation imposed on providers of electronic communication services should not be considered, particularly in the view of the safeguards and control attached to administrative access to and use of connection data, as an interference justified by the right to security granted by Article 6 of the Charter and the requirements of national security, for which the member states alone are responsible under Article 4 TEU. Sorry. So we just have a quite quick zoom on the answer to this question, and that, as we can see, judge interpret the directive like Article 15 does not in principle preclude a legislative measure which permits the competent authority to order provider of electronic communication services to retain traffic and location data of all users of electronic communication system. With a serious threats, so member states concern is confronted with a serious threat as referred to in paragraph, etc., to national security. So the national security can give the state the opportunity to oblige the provider of electronic communication to keep the data, but only if we have a serious threat. So reasonable. The judge precise, genuine and present of foreseeable risk of serious threat of the national security. So it's very, very more restrictive that the French government was applying in France during all those years. So we understand that the judge, the European judge, give some elements to understand in which condition the national security can apply. And we, at the time, we don't have any jurisprudence of the Article 23 of GDPR, but using those elements, we can understand the limits of the using of those exceptions. And we understand that general surveillance can't be legal under the directive or under the European law in general. So through this case, the judge defined the conditions that must be met to impose on services provider the collection of personal data. However, the judge illustrates an example of national security using like terrorism, because the judge used terrorism during all the case. So using terrorism, but does not define national security from a legal perspective. So he said that, okay, terrorism is national security, but national security is not terrorism, is not the same definition. So we still not having any element of what is concretely the national security. So this case is a major importance as it again prohibits the general surveillance and imposes condition on the processing of such data, because the connection data are very, very, very deeper than personal data. As I said to you at the principle, we can know a lot of more using this kind of data on you than using just your name. So, and it is now know that Article 15 of the directive only applies where there is an actual foreseeable threat on terrorism. But however, okay, sorry. However, although this case has allowed a breakthrough in this area, the vagueness of the national security exception still poses certain problems for the implementation of law and its application. So I put you in the presentation all the elements given by the judge to understand in which case you can apply the national security, and I can send you the presentation after my speech. And what about the European Court of Human Rights, so the Council of Europe law? And recently, the European Court of Human Rights has issued two very interesting judgments on surveillance, establishing stricter rules than in the past. These criteria have a direct impact on the national security ground, since when it's invoked, it will have to meet all the conditions given by the judge. So first, we are particularly interested in the famous Big Brother Watch versus UK. I'm sure that one of you have heard this case. Handed down on the 25th of May by the European Court of Human Rights. In this case, the UK government used the national security exception to carry out a widespread interception of connection data. But this connection data came from UK, but also from other countries, because it's an economic question. But when you are when you provide services on connection, you use the cheaper. So maybe the cheaper passed by UK and Russia and Switzerland, and you use the cheaper one, and UK was intercepting all the data in the UK territory. So it concerns national data, but also other citizen data. And I have a quick check on Big Brother. Okay. However, as we can see, the European Court of Human Rights is less involved in the data protection than the Court of Justice, in my opinion, because the way to make the jurisprudence is not the same. The member states are more in the Council of Europe organization, and it's very difficult for the European Court of Human Rights to have a proactive behavior than for the Court of Justice of the European Union, in my opinion. So the court said, while Article 8 of the Convention does not prohibit the use of bulk interception to protect national security, and other essential national interests against serious external threats, and states enjoyed a wide margin of appreciation in deciding what type of interception regime is necessary for this purpose. And after precise in operating such a system, the margin of appreciation afforded to them must be narrower, and a number of safeguards will have to be present. So after we have another precision about the condition of the national system to be respectful with the Article 8 of ECHR. So it was sixth condition before, and now the court precise. The court will examine whether the domestic legal framework clearly, despite the ground on which bulk interpretation may be authorized, the circumstances in which an individual communication may be intercepted, etc., etc. I let you read it at home because it's too concrete and too difficult to see how we can have all these conditions. But what I want to tell you is, however, the Strasbourg Court does not provide a European definition of national security. Judges consider the position of the party on the issue when stating the fact, but does not return to it in its reasoning, because the judge of Strasbourg start with using national security definition of the parties, and after give all these exceptions to apply the national security, but still doesn't giving the definition of the national security. So it's very interesting to see that the European Court of Human Rights give us all the condition to be respected to use the national security, but without making like a framework of it. Because we can put here, I don't know, COVID, for example, using data for fighting COVID, but even if we saw that it doesn't work, but if we respect all this condition, it will be okay under the Article 8 of the Convention, under Convention 108 plus, and that's all. We don't have definition of national security, so we can put that we want inside. So this is my point of view, and I hope that you can have all the element to have yours, but it is interesting to see that, and the judge repeatedly highlights the bilateral issues of national security and the risk of the widespread surveillance. These risks are directly linked to the national security exception of data protection. And without defining this exception, the judge outlines its contours. It outlines the various interests involved and set out the minimum condition to be met under Article 8. But still a very strange concept that any court in Europe can define. And we have at the same date a second case law very important, that is Centrum for Rat Visa, and we have all this exception in this second case law. That means the judge of Strasbourg is making a very strong jurisprudence on this question. And the development of arguments, it's approximately the same as Big Brother. We will find the condition which have to be respected to comply with Article 8 under the 275 paragraph of this case law. And there has been an evolution in the case law of the European Court of Human Rights. Because if we compare Big Brother and the second one, Centrum of Radvisa, with the past jurisprudence, we see clearly an evolution. And the judge start to give element of reflection on the condition of national security. What does it mean? Even if he doesn't give any definition. So, sorry, I will check now on the last, on the past of the jurisprudence. We have the Kennedy versus UK 2010 jurisprudence of the European Court of Human Rights. In this case, it's about also national security, and the court emphasizes that the condition of foreseeability does not require states to set out exhaustively by name the specific offense which may give rise to interception. So what does it mean? It means like a state hasn't the obligation to give very precise definition of what they put in exception of data protection. And after the judge precise, the applicant criticized the term of national security and serious crime as being insufficiently clear. The court disagrees. It observed that the term of national security is frequently employed in both national and international legislation and constitute one of the legitimate aims to which under Article 8, paragraph 2 itself refers. So yes, a lot of national and international legislation use the national security to create exception, but no one defines it. And we still have not a common definition of national security. So this case is from 2010, and we can see that we start to have an evolution. Before the judge was just saying, okay, the claimant said that it is not precise, but I refer to international and national legal tools. And now he tries to frame it with condition of application and with example of application to be met with the Article 8 of the Convention. In a general point of view about national security, because we just seen like the genesis of it, the political concept, the legal one, and the jurisprudence. In cases which raise the issue of personal data protection, the court has held that the authority's margin of appreciation is wider, because where there is not a consensus among Council of Europe member states on the relative importance of the interest at stake or on the best means of protecting it. So this is by essence the national security, because we don't have consensus between the 47 member states on national security. And she said it, the Human Court of Human Rights said it in 2003. And in matter of national security, she presided after in another jurisprudence. So those exceptions create a wider margin of appreciation for the member states, And in my opinion, both Council of Europe and EU can't define in law what is national security. Why? Because the national security comes from the states, and with the help of the case law, it is established in which case this ground can be invoked, as we said, like by the European Union Court of Justice, and also which condition must be met for processing connecting data when this ground is invoked, as we just seen with Big Brother and other conditions quoted like in Centrum for Rat Visa. This framework remains draft, and is it, for me, insufficient, but it is a first step, and a first step for a very, very long process, because even if we will not have any definition, a common definition of national security, we can have a common principle of what we include in and what it have to be respected for the human rights and for the data protection rights. And now, what are the consequences of such exception of fundamental values of our society? I think that all of you can imagine what is the problem when we have the French government collecting all the data connection of the country. We can all imagine that can be problematic when the UK collected your data, even if you are living in the North Russia or south of Spain or another country, and you don't know what they are doing with your data. So basically, the consequences are human rights breaches. So, for example, during the CPDP conference in 2018, a lawyer was giving an example about his own story. The intelligence services. The intelligence services placed him under surveillance, and they listened to his conversation by mobile phone, by the telephone number of the office, and all the conversation were collected by the intelligence services. And the argument was that he had defended some terrorists in the court, and therefore there was a risk to national security. The problem is that in such an example, several fundamental rights are violated, are breached. For the first one is the lawyer's fundamental right to privacy, and the fundamental right to privacy for his family, friends, all the people that call him. You have also the right to a fair trial of the person's defense, because when you called your lawyer, you can give him some elements to the trial, and after it, when you get the trial, you have such elements in the adverse parts. And it's problematic because some elements are under the professional secrecy. So lot of fundamental rights were breached in this case. And I really asking you if you, when you call your lawyer for a divorce, for example, do you really want to tell what do you say to him, to all internet, to all the intelligence services, to, I don't know, to everybody? Because when your data are collected, is the diffusion is so close to you. And to conclude my presentation, because I gave you an example of the consequences, but we can imagine a lot. So to conclude, national security for me is a recent and very, very, very complex notion in law. We need to take care of using those new tools as an exception of fundamental rights. At the same time, as everybody, I want to live in a safe place and I agree to fight terrorism, but I don't want to lose my fundamental rights in the name of an hypothetical security. And the lack of transparency of our governments on the effectiveness of surveillance measures in this area confirms my idea. And I have a lot of examples in French law if you need. I can send you those laws that I found problematic for my liberties and for the effectiveness of the security. And in my opinion, at an European level, the problem is even more complex because we have a common standard between 27 or 47 states is very difficult. And I think that we can't find a common definition on national security at an European level because it is in essence a state-specific concept because it is national security. I explain myself, having 47 countries in the Council of Europe leads to perhaps 47 definition of what is national security. Therefore, Europe is the broadest sense, is not in a position to define this state-specific concept. This will mean touching on the most Hegelian competence of the state and will not be effective in my opinion, and very difficult to accept diplomatically. So I think that on the contrary, public security can be defined and has been defined by the institution. We saw it in all the economic rights in the EU, and we saw it in the European Court of Human Rights with the case about sexuality, guns. We have a lot of jurisprudence on the public safety and we have definition of it. But how to deal with the exception under national security, GDPR 1, the Convention 108+1, the national security under the directive of 2002. I think and I hope it is up to the judge, national and European, to do this jurisprudential work. It will be appropriate to work on a strict framework of the implementation of this exception, which is beginning to appear in particular in the judgment of the EU Court of Justice. Because even if the European Court of Human Rights try to give conditions, the Court of Luxembourg is more proactive in this way. So thank you for listening. I forgot the last page of my presentation, but if you have any question, just ask me, and it's time, I think, to Roman to take the floor.
Yes, Julie, thank you for your detailed and elaborate presentation. And I would like to say to the audiences that we already received several questions, but if you want to ask Julie directly and receive instant answer, you can do it by yourself. And while you are preparing, I will go through the questions that we receive in our chat. First question is a little bit procedural one. It's like this. How many countries are part of the convention and whether the convention is legally binding? What is the difference between signing and ratifying the convention? Julie, you hear me?
Okay.
Yeah.
So we have in Convention 108, we have 55 countries at the moment. And when you sign the convention, is like a diplomatic way to show that you are in. But how can I say?
Yes.
Yeah, when you ratify the convention, it's legally binding. So you
Yes.
can you can see this convention opposed by a judge or a lawyer in a trial. So if you just sign it, it is not legally binding, but have we seen by some courts, it shows a motivation to be in. So even if it's not legally binding, you can argue, if you are a good lawyer, you can argue that the state have the volunteer to go in this convention. And at the moment, we have 55 member states in the Convention 108, which is the only convention of the Council of Europe opened all over the world. So we have African countries, American one. We have also, we start to negotiate with Vanuatu, which is in a Pacific country. And little by little, we combine all the continents.
Okay, thank you. So, and I will also add that Ukraine ratified the convention number 108 in 2010. And due to this fact, it is legally binding part of Ukrainian national legislation. And more precisely, we have a specialized law, the law on personal data protection, which is a little bit old now, a little bit outdated, but it is a building basis of Ukrainian data protection law. The second question is quite specific. Please listen very carefully. Is there a practice in European Union countries of merging state specialized register into one universal register? And does this practice pose a significant threat to human rights?
So it's a more technical question. In the EU, we have a lot of register because whenever there is a data processing operation, you have to create a register. So what I know is that the more data are processed by a single operation, the greater the risk is for human rights. So it is not the registry in itself that include a risk to human rights, but the processing. Because we speak about processing when you have a collection of data, when you process data in itself, that means, for example, I collect all your name to create like a new webinar. So the way that I collect your name and create a new webinar is a process, and this is what creates the risk for human rights violation.
Okay, thank you. So the risk is in the processing of data, how it's handled, and for which precise purposes it is being used. Yeah. And according to the convention, users should be always informed about what data is registering, for what purpose, for how long, and they have right to have access to this data, to ask it to be changed or removed. So this is the language of the convention itself. Yes, yes, please.
Just I add a precision. National security is an exception. So yeah. When we enter on the Article 23 or Article 11 of Convention 108, we have this exception that you don't know which data, when, during how many time, and for what. This is the purpose of those exceptions.
Yes, understood. The third question is connected to the first one. Is convention work only in Europe? And as you mentioned, it is not. But maybe can you explain why this precisely this instrument of Council of Europe, this convention, is opened worldwide to Latin American countries, to Northern Africa? Is there like historical background to this situation or any other kind of that you know?
So the sorry, the Council of Europe was created in 1949, and it was in peace objective, and the Convention 108 was the first convention of data protection in the world. The first convention, international convention of data protection in the world. And it's like an example for external countries of Europe, because for the first time, we register all the good practice. We try to frame all the use of those data, and we opened the treaty to the rest of the world because of this good example. Because yes, the Convention 108 was the first one and was very, very effective. And without Convention 108, I think that the GDPR didn't exist. So the Council of Europe also played an important role in the transition of former Eastern Bloc countries. So we opened it to the 47 members, and after showing the rest of the world that 47 members can ratify it, aims to open the convention of all over the world. And I don't know if you want to add something about the Council of Europe, Roman.
Yeah, actually, I can say that I will finalize that Convention 108 is a model convention because Western European countries have advanced legal experiences in artificial intelligence, in IT commerce, and that's how this model law become a basis for national legislation worldwide. And more precisely, in the case of Ukraine signed European Union Associated Agreement, and one of the clauses of this agreement, namely Article 15, demand Ukrainian enterprises, state or private, to guarantee the same legal protection of its citizens in Ukraine as it's done in Europe due to GDPR regulation. That means if Ukrainian citizens, private or public enterprises, NGOs, would like to have a business or any kind of other activities with the European Union, our local national legislation should be in line with the requirements of the GDPR, also and precisely regarding personal data protection. So there can be two ways to explain why convention is so worldwide use. First, it is model text, it is legally perfectly written, and secondly, business interest to have free flow of information, free economic activities between countries. Yes. And yeah, we have our first question. It's concerned medical data precisely, and it's written like this: whether the convention protects medical data as a sensitive one, and how?
Okay, the medical data is sensitive data, because there is two kinds of personal data. You have the classic one that you find at the article 2 of the Convention 108, and you have in article 6 of the Convention 108 plus, and you have in the article 6 of Convention 108 plus all the sensitive data. In this category, you have genetic data, personal data relating to offenses, criminal proceedings, convention related to security measures, biometric data, personal data revealing racial origin or political opinion, trade union membership, etc., and the medical data. And those data to be proceeding needs more safeguards than the others, because they can lead easier to discrimination or to a human rights breach, for example.
Okay, yeah, this answer satisfied me, so I will go a little bit further. Our fifth question concerns the protocol to the Convention 108, and it's namely stated like this: what changes were done to the convention by protocol in 2018, and why?
The protocol changed some very specific aspects. As we've seen during the presentation, it changed the state security for national security. But in a general way, we have stronger requirements regarding the proportionality and data minimization principle, lawfulness and of the processing. So data minimization is to collect only the data that we need to process our processing. And that means it's connected with the privacy by design, meaning that you have to anticipate or at maximum that you just take what you need and no more, because more you take, more the risks are higher. After, we have also the extension of type of sensitive data that I just said during the lecture of Article 6 of the Convention 108+. We have also the obligation to declare data breaches, and it's what's happened with EasyJet 1 year before, I think, because they lose a lot of data and they are obliged to send an email or call the data subject to tell, okay, we have lost all your data, even your bank account, for example. We have a greater transparency of data processing, because you can ask now what is the finality of the process. You can ask how many times they keep your data. You can ask also, it is a pseudonymization or anonymization, how does it work, etc. And we have also a new right for the person. It is all the documents on algorithmic decision. You can find it on the data protection page of the Council of Europe. If you need it, I will send you the link. We have also stronger accountability of the data controllers, because before it, we didn't put a lot of responsibility of the data controller, but now he have to make the register by itself, and he have to keep the control. We also have lot of regulation on data flows, transborder data flows, because of the wider application of the Convention 108, and yes, we can find other rights, but if you want to see our videos, I can send you videos of the modernization of the convention, if you need more precision.
Yes, please send it to me, and after lecture I will prepare a letter to the registered participants. It will be lovely, I suppose, to follow up on the lecture and to come back to the video a little bit later. Thank you. And I can add that originally a convention was adopted 40 years ago, and next year, namely 28th of January, in European Union, it's celebrated as European Data Protection Day. So during these years, technology developed significantly. The usage of social media, the coverage of internet grew significantly, and the law of such great importance can't stay not touched. That's why there was work for several years done by the best scholars worldwide to update Convention 108 with the protocol. And as Julie mentioned it, the protocol addressed in particular the risk of usage of big data, algorithms, and artificial intelligence biases. Yes, and the next question is connected to this one, and it put like this. What is the legal difference between the convention and protocol? How many countries signed the protocol and whether it's in force? It's a procedural question, Julie.
The goals of the protocol, it's first to modernize the convention because it was from 81, so a little updates, it's good, and is to further integrate the various regulatory frameworks developed in different regions of the world, including the European Union, and to provide a multilateral instrument. But also we need to upgrade transparently to take into account all the modernization of the digital environments. So data flow across border, also the using of artificial intelligence. We had to make like some precision of the protection of data. And for the how many countries signed the protocol and whether it's in force, at the moment we have 13 countries ratified the protocol. The last one is Uruguay on the 5th of August. And we need 30 we need.
Yeah, I understand your point. Technically speaking, in the nature of legal wording, protocol is a legal instrument which complements, amends, or modifies the main treaty. But originally, as the so let the name protocol don't misplace you. The protocol has the same legal power as the convention, because protocol is the convention, is updated version of the original document.
The only fact is, for example, even the countries of the Council of Europe are not obliged to ratify the protocol. But if they don't, it will not enter into force. Because we, I didn't remember, but I think it's 35 ratifications.
Understood, yes. And in the chat, we can see the question. I would like to ask how the Council of Europe Convention correlates with European Union legal order, namely General Data Protection Regulation Law, and, for example, Police Directive. Can you elaborate about this topic?
Okay, so the Convention 108 operates in a separate juridical system than GDPR. However, all the 27 EU member states are subject to both the GDPR and the Convention 108, and maybe 108 plus. But the advantage of the Convention 108 is that it has no jurisdictional limits, as was the case in the international privacy case. It is a very famous case in the EU because the party of this case used the Article 4, paragraph 2 of TEU because the European Union have all the common foreign and security policy, which is not in his own competence. So it's competence of the states, and they use it during this case to put out of the competence of the court the question about data protection. So this is the advantage of the Convention 108. A state can't tell to the Council of Europe, we have to do it because it's our competence, and this is the point. No, Convention 108 applied even during the application of the exception of national security. We have safeguards, we have a condition, we have a control. All the citizen can ask to a judge to check the legal tools of the convention in a trial. So this is the difference.
Thank you, and I can give also small historic background. So as we mentioned, Convention 108 was adopted 40 years ago. So this legal instrument of Council of Europe regulate the protection of personal data issues far before European Union legislature start to work on these issues. In European Union, first union law, so-called Data Protection Directive, was made up into force and adopted in 1995. And then in 2018, it was replaced by GDPR. So historically speaking, chronologically speaking, the convention laid the background for the GDPR. That's how these two legal instruments are not contradicting each other, just covering GDPR cover European Union legal system, and Convention 108, both European Union and the world. So these both acts are in full power, and they are harmonized to each other.
But Roman, don't tell to the European Union that they are inspired by the Council of Europe, because they will be very, very upset on you. So don't tell them.
Okay, thank you. We have 5 minutes left of our conversation, and participants, you can still ask the final questions if you would like to know something deeper. And I will go to our last registered question. Is there a link between the provision of the convention and the case law of European Court of Human Rights? Yeah, I can say that in order to find your answer, I advise you to use Hudok, a specially developed web portal of Court of Human Rights, where all court rulings and decisions are stored in an orderly manner. And I would suggest Ukrainian participants to use Hudok in English, because there is Ukrainian version, but it is not so correct as original English and French one. So preferably use Hudok in English environment, and then you can administrate you can look for specific case law, just inserting Article 8 in the search engine, and then you will find precise case law on the issue of data protection. Julie, merci pour votre contribution, and we are currently finishing our presentation. I would like to, on my behalf and on behalf of my organization, to thank you for your findings for your research work and to wish you a great academic and human rights career in future.
Thank you very much. It was really a pleasure for me because it's the topic that I love. But if one of you have any question, you can send me an email. I will, Roman can give you my personal mail address. Take care because it's personal data, please. And my LinkedIn also, and don't be afraid. You can send me any question do you have. I speak English, Spanish, or French, so as you prefer. And I'm wait your question. If you have another one during the night, maybe some question will come.
Thank you. And I will finish by saying that I would like to send you also a feedback form to participants. Your feedback is important for us to modify our webinars in a productive way. So I will prepare educational materials for background reading on the topic and feedback form. And if you are kind enough, you can do the feedback and it will help us to perform better. And so currently I will close up the chat section and would like to say to you goodbye and have a nice evening all. Goodbye. Bye.
Thank you.